Hey, Heaton here. Today we're going to jump into everybody's favorite non-controversial topic of Roe versus Wade. We're going to get into the jurisprudence, what the decision said, what it meant, and what happens when probably Dobbs v. Jackson overturns it. This is a me talking to you episode. It's a monologue episode as opposed to an interview. And so I am going to, instead of just me talking like this, give you some stock footage as it goes on. The audio, great stuff. I did a lot of research for this. You'll learn things. But I don't want to just, I can't memorize it. I don't have that good of a memory. So I'm just going to read the script and put in some grainy stock footage that's completely unrelated that I found that is fair use from the 1960s. It has nothing to do with anything. So as you're listening to this, please don't infer there's some sort of clever allegory going on. If you see like Model Ts and we talk about abortion or something like that, like it's just to keep the algorithm from voting me down and to keep you from getting bored. So enjoy. I might as well have some fun with this episode because it's probably going to get me in trouble. So before we get started on what will be a very contentious topic, let me tell you my favorite Roe versus Wade joke. You and I are in Washington, D.C. I'm just starting out in stand-up comedy at this time. During the day, I work on Capitol Hill, but several times a week, I slink into a basement or an attic or an abandoned boiler room to lob jokes at drunks in suits. Right now, up on stage, is my buddy Hormoz Rashidi. He's starting out too. He's not yet at the world's famous comedy store in L.A. as he will be, but he's good. He's very funny. He's got the audience on his side. They're loosened up, relaxed, laughing. And then Hormoz says,
"Oh man, Roe versus Wade. Roe versus Wade is a controversial subject. It might be too soon. I just want to take a quick poll of the audience, see where you guys stand on the issue, okay? Is that cool?"
The whole audience tenses up. You can even hear in that audio clip I just played that people do not want to discuss Roe v. Wade at a comedy club. The postures of everyone in the room stiffens. Sphincters tighten. Everyone is uncomfortable. And then he says,
"Raise your hands or clap if you're a Wade supporter." All right, it's a Roe crowd. We got a Roe crowd. Yeah, it's a Roe crowd.
I don't know if I can quite capture the psychic release of that moment in a podcast, but this joke always kills in person because while everyone feels very strongly about abortion, it turns out very few people know anything specific about Roe versus Wade. The phrase often just acts as a proxy for pro-choice. And we now understand that that landmark 1973 Supreme Court decision is poised to be overturned in a matter of weeks. Today, you and I are going to wade into the guts of that decision, the grounds on which the Supreme Court codified abortion rights. And we will tackle Dobbs v. Jackson, the court case primed to overturn it, and then a glimpse of what happens next. Welcome to the Political Orphanage, a home for plucky misfits and problem solvers. I have assiduously avoided the topic of abortion on this show for 3 consecutive years. Thanks a lot, whoever leaked Alito's memo. Probably Edward Snowden. Thanks, pal. If you're new to the orphanage, I highly recommend you listen to the Judge Week episodes we did a year and a half ago. They explain basic jurisprudence and the actual intellectual conflicts on the Supreme Court, which is not typically how the media portrays court reporting. I am going to run rebroadcasts of some of those episodes this week following today's program, so if you are not an attorney but you're interested in law, or maybe you could just use a little bit more pillow talk for after you've seduced a litigator, check those out. Roe v. Wade, Dobbs v. Jackson, Rocky v. Drago. These are all arguments about what the Constitution says, not what it ought to say. Literally no jurist writing for the court, or penning a dissenting or consenting opinion, or even drafting erotic judge literature, claims to be arguing in favor of whether abortion ought to be legal or otherwise regulated by the states. The question the Supreme Court concerns itself with is, are these rights, in this instance that of abortion, present in the Constitution? Again, not should these rights be present in the Constitution, but can we find them in there and affirm them as law? Originalists interpret the Constitution as the plain language of the text as understood by its writers at the time of ratification. They agree that society changes and government needs to evolve, and therefore so does the Constitution. However, originalists want those changes to the Constitution to happen through amendments via a clear democratic process, and not through the purposeful revision of definitions as subjectively interpreted by unelected judges. So in a hypothetical example, this is hypothetical, if the state of Iowa decides to interpret the word person in the Constitution as a human being from the moment of conception on, a proper originalist would say that is not the definition of person as employed by the people who wrote the Constitution. You are retconning a more expansive definition than was ever legally ratified. You're trying to outlaw abortion by changing terms and therefore making up law. If you want to define human life as starting from conception, you need to pass a law to that effect. You can't just have a judge change the wording to create the outcome you want. Conversely, living constitutionalists think more like this. You can't change the equation of what is written in the Constitution, but some of the words are by nature variable. These variables are designed to be interpreted in light of present circumstances. For example, the Constitution affirms a right to a speedy and public trial. But what constitutes a speedy trial is very different for people who got to and from court by horse versus today when I can show up to my parole hearing on Zoom. And also, so can my horse for his hearing. The Constitution proscribes cruel or unusual punishments. But back in the day, thieves could be branded in the face, and that was not considered cruel or unusual, whereas modern society would presumably take a dim view of branding a shoplifter in the face. So the term cruel and unusual is subjective rather than objective, and ought to be interpreted in light of modern society and changing mores, rather than the feelings of old dead white guys who wore powdered wigs and pooped in holes. They wrote the equation, but some of the variables therein are meant to be regularly reinterpreted. Those are the two general camps of jurisprudence, and both originalists and living constitutionalists alike nominally decry judicial activism, the great sin of jurisprudence. Judicial activism is when a judge decides there ought to be a law, but there isn't one. So the judge makes up the law and then says, I don't know, if you look at the Constitution and you turn your head and squint, you can kind of see how this law I discovered was already technically kind of there. I don't know, you have a couple beers, 2-3 beers maybe. You can see where I'm coming from with this law. Should have been a law anyway. So that's a basic primer on constitutional law. I will elaborate on that in the rebroadcasts of Judge Week this week, but that's the basics of constitutional law. And we're going to be living in constitutional law for this episode. We won't be going into the efficacy or effects of specific state policies, although since abortion is now going to inflame all discourse for the next few years, we will no doubt eventually cover that. Nor are we tackling the ought of abortion. We're not covering the morality of it. We're concerned with is, namely, what the Constitution says, what Roe v. Wade says, and whether or not the one contains a right to abortion affirmed by the other. So, if you are perched next to your typewriter, prepared to fire off an unsolicited 7-page manifesto about how abortion is murder, or alternately, you're about to mail me some all-caps slam poetry inspired by your Margaret Atwood tattoo, this episode's not about that. This episode is constitutional analysis, and I'm doing it so that you will have a working knowledge of Roe v. Wade and Dobbs v. Jackson, which I suspect the media will be talking about quite a lot over the next few months without ever actually explaining what happened or what they really mean, just the outcome of them. Remember, we're just discussing constitutional analysis, so everybody calm down. Don't try to kill or cancel me for not adopting whatever pro-life or pro-choice position you have or the volume level you prefer I espouse that opinion at. In fact, I'm so worried about talking about this. Again, I haven't talked about this on the show in 3 years. I was so worried about discussing this because I think it's probably a no-win scenario for me that I got a special musical guest this week to try and allay your concerns. Mike?
Please don't cancel. He knows furious. Abortion is a topic where no one ever wins. Half the people are furious no matter what he says. The other half are raging that he might be in league with Satan. No, please don't cancel Heaton. Oh, he's not that bad. Please don't cancel Heaton. Don't you know it'd be so sad? Oh, it'd be so very well begotten.
Thank you, Mike TV. Okay, let's jump in.
Good evening. In a landmark ruling, the Supreme Court today legalized abortions. The majority in cases from Texas and Georgia said that the decision to end a pregnancy during the first 3 months belongs to the woman and her doctor, not the government. Thus, the anti-abortion laws of 46 states were rendered unconstitutional. More on this story from George Herman.
Well, I hope that damned leaker is happy, because I had to spend all of last week crawling my way through Roe v. Wade and self-teaching myself about stare decisis and substantive due process. I'm not even sure how to pronounce these terms, although I've been reading about them quite a lot. Let me tell you, Roe v. Wade, way less entertaining than the stuff I usually read in the tub. There's no sex scenes or werewolves or nothing. Just a bunch of stuff about the history of abortifacts and English common law, followed up with some hospital procedure regulations and judicial cliff notes. Frankly, I'm saving you a lot of boredom by not having to read that decision, or the Alito decision, which countermands it, which we'll also talk about today. Allow me to summarize Roe versus Wade. Jane Roe, a pseudonym, wanted to get an abortion in Texas, but was denied that procedure due to state law. At the time, Texas banned all abortion, with the exception of medical interventions to save the life of a mother. Henry Wade was the Texas district attorney named as the plaintiff in the case. The court ruled 7-2 in favor of Roe. Justice Harry Blackmun, a Nixon appointee, wrote the opinion of the court, with future Chief Justice William Rehnquist and Justin Byron White dissenting. I also read those dissents, and they also do not include vampires or nudity. Thanks a lot, gavel heads. So here's a summary of the judicial reasoning in Roe versus Wade. Here it is. The Constitution protects certain unenumerated rights, which, though unstated, are fundamental, long-standing liberties in the American tradition which are presumed but unwritten. One such unenumerated right is that of privacy. The decision of whether or not to have an abortion is a deeply private one, making it relevant to the right of privacy. First and second trimester abortions were specifically unregulated in the early republic and were only significantly curtailed by states starting in the late 19th century. Therefore, this privacy right has historical weight in the American experience. Thus, the court is stepping in to protect a historically grounded constitutional right to privacy vis-a-vis abortion from unwarranted state interference. Very likely you're thinking, wait, what? Why did Blackmun lump abortion in with privacy? What do they have to do with each other? And why would that even matter? The Constitution talks about search and seizure, but it makes no mention of a right to privacy. Good question, savvy listener. To understand Blackmun's reasoning, we have to unpack a legal theory called substantive due process. The idea that the Constitution protects certain fundamental rights even if they're not explicitly mentioned by it, and that from time to time the court needs to step in and protect these fundamental historical rights from majoritarian overreach. Now, due process, you and I were already probably familiar with before all of this. Due process refers to the government dotting appropriate I's and crossing T's. You can't send someone to prison without a trial. Cops can't go into a house without a warrant. The city can't confiscate your koi pond without going through eminent domain and all of the processes therein. Due process is a fundamental legal doctrine going all the way back to the Magna Carta, which says the state has to abide by designated rules and procedures rather than arbitrarily dispensing decisions. Substantive due process is different. Substantive due process stipulates that the Constitution contains unenumerated rights which can be found in the emanations and penumbras of the Constitution. Usually when someone invokes substantive due process, what they're essentially saying is there are certain obvious yet unwritten rights which are so fundamental and widespread in the American experience that they should be presumed constitutional even if not explicitly stated by it, and afforded constitutional protections. And generally they will have kind of a tether to some very broad term like liberty or something like that. An example of this line of thinking comes in Moore versus City of East Cleveland, in which a zoning ordinance prohibited a grandmother from living with her grandchild. The Supreme Court ruled, quote, "The Constitution protects the sanctity of the family precisely because the institution of the family is deeply rooted in the nation's history and tradition," end quote. Or, in other words, the sanctity of the family is so intrinsic to American history and spirit that no one bothered to put it in the Constitution. But it's such an obvious right that we can lump it in under the broad category of liberty, which is in the Constitution. The most famous example of this kind of reasoning comes from Griswold v. Connecticut, in which the Supreme Court struck down a state ban on contraceptives, on the grounds that regulating birth control violated a long-standing presumption of marital privacy in the United States. Justice William O. Douglas wrote, quote, "Would we allow the police to search the sacred precincts of marital bedrooms for telltale signs of the use of contraceptives? The very idea is repulsive to the notions of privacy surrounding the marriage relationship," end quote. In other words, while privacy, and specifically marital privacy, are not mentioned in the Constitution, they are so ingrained in American culture and legal presumptions that they might as well be constitutional, and so the Constitution should be extended to protect them. The court employed this sort of logic during the Lochner era as well, in the early 20th century, although they didn't call it substantive due process at the time. In that period, the Supreme Court would strike down various state laws about minimum wage, maximum work hours, and other labor regulations on the grounds that they interfered with right to contract. Now, similarly, the Constitution does not mention a right to contract, but the court of that era thought, well, no, not technically, but clearly contracts are an ingrained, widespread, fundamental legal right, and American philosophy is built upon the ideas of John Locke and Adam Smith and contains an august lineage of capitalists and top hats. The 14th Amendment says that states cannot abridge life, liberty, or property without due process. So if you have a right to liberty and property, then you also have a right to contract and voluntary exchange. Therefore, the Supreme Court rules that the government cannot interfere with a voluntary contract except in narrow, extenuating circumstances. I think substantive due process is mostly loophole gobbledygook. There's no way to get to that position as an originalist, or for that matter, as a good living constitutionalist. An originalist would hear something like that and say, right, friend, there are no invisible rights in the Constitution. You're just making up laws. Whereas a living constitutionalist would say, certain variables in the Constitution have wide latitude, but you don't get to add new variables except via amendments. You can't change the equation without amendments just because you feel that an important historical presumption ought to be grandfathered in. Now, don't get me wrong. I like the outcomes of all those decisions I just mentioned. I'm glad condoms are legal. I'm wearing one right now, just in case. I think you own your own body, and you can have sex with any consenting adult you want, even if they want to pay you for it. I would totally ratify a constitutional right to contract if it were on the docket, and also sex work. But I fall short of saying, because I emphatically feel that the concept of American liberty ought to allow people to pay for sex, a right to prostitution is therefore an unenumerated right. I wish it was. It's not. My abstract classical liberal philosophy informs what I think the law ought to be, but it doesn't mean the law is that way when I take a look at it. So I'm very skeptical of substantive due process. It rather strikes me as jurists peering into the mists of history and identifying secret rights which they slip into the Constitution. Although, to step up for substantive due process, I do see some value there, and I do agree with part of it. It does make sense to me insofar as you can deduce rights through other existing rights as a logical syllogism. Whereas talk of penumbras and emanations is kind of the mystical side of the judiciary, substantive due process also entails the idea of rights which are, quote, implicit in the concept of ordered liberty, end quote, which makes sense to me, inferring the existence of unstated rights via logical syllogism. All right, I know I just bubbled up a bunch of weird terms here. So here's what I mean by this. Most people would say we as Americans enjoy, as a right, freedom of association. However, the Constitution makes no mention of such a right. In the 50s and 60s, some states tried to ban activities of the NAACP. In other periods, states tried to ban unions. Courts, rightly, struck down those bans, saying we have constitutionally protected freedom of speech, assembly, and petition. If you connect the dots between those stated rights in the Constitution, there is also necessarily, though implicitly, a right to freedom of association. It's not that freedom of association accidentally got left out of the Constitution or was so fundamental and presumed in the American experience that nobody bothered to write it in, and now our mystics have peered into the mists of history and drawn it out. Rather, it's that our logicians have rationally deduced the existence of some rights as a necessary confluence of other overtly stated rights. The Constitution protects X and Y. Therefore, by doing so, it must also protect unstated right Z. We're not creating right Z. We're logically deducing that if you have X and Y, you also have to have Z because of the way the two connect. That syllogistic reasoning does make sense to me. Jurisprudence through logical constructs. Which brings us back to Roe. Roe v. Wade doesn't go the syllogistic route. It goes the penumbras and emanations route. The best I can find in terms of syllogistic reasoning is the following abridged paragraph from the ruling. The Constitution does not explicitly mention any right of privacy. In a line of decisions, however, the Court has recognized that a right of personal privacy does exist under the Constitution. In varying contexts, the Court found at least the roots of that right in the First, Fifth, Ninth, and 14th Amendments. And then he cites a dozen or so court precedents that are to that effect. So it's possible that one or more of the cases that Blackmun cites does that syllogistical legwork to show how privacy is a logical deduction of another right, which Blackmun then in his ruling links to by saying abortion is a deeply personal decision and therefore a private decision, and so is protected by right to privacy. However, if any of those cases employ that kind of syllogistic, inherent to ordered liberty reasoning, Roe v. Wade doesn't bother spelling it out for us. Rather, it just says the Court has affirmed there's a constitutional right to privacy and gives us some footnotes. When someone wants to use substantive due process to prove that there is a widespread, fundamental but unstated historical right, they do have to make a case that it's historically rooted and not something they've made up, kind of like common law. The idea here is that if you can't provide historical evidence of a widespread use of such a right, then it's not actually fundamental, and therefore it's not protected by the Constitution. So for that reason, Roe v. Wade and Alito's rebuttal to it both drop a lot of history up front, references to English common law, early colonial ordinances, and antebellum statutes, and so forth. Because Roe is making the case that abortion is a historic but unwritten right, which the Supreme Court has stepped in to protect from unwarranted state interference. Whereas Alito is saying, no, the states have always regulated abortion. This is not some state power grab over established individual rights. So in Roe v. Wade, Blackmun spends a lot of time showing that abortion was not explicitly banned throughout American history, but generally regulated only after quickening, which is a new old-timey term for me. Quickening is when a woman feels a baby move within her. According to Blackmun's historical analysis, prior to the moment of quickening, as in its antecedents in English common law, abortion was not even considered a crime. Blackmun then asserts that state restrictions on abortion are of a relatively recent vintage, dating from the latter half of the 19th century. Or in other words, he says that for most of early American history, states only passed laws dealing with abortion at a very late stage in the process. Curiously, however, Blackmun doesn't leave it at that and say, therefore, the Constitution protects a historic right to first trimester abortions. Rather, he asserts that there is a constitutional right to privacy, and that because the decision of whether or not to have an abortion is deeply personal, i.e. private, then abortion too is a matter of privacy. Which strikes me as a weird friend of a unstated constitutional right sort of argument. But I think Blackmun wanted to lump abortion in with privacy because he thought that it had a stronger precedent than any other unstated, unenumerated right. The court had already made a lot of decisions affirming a constitutional right to privacy, like in Griswold v. Connecticut, whereas it had never claimed abortion as one. So I think Blackmun wanted to tether abortion to the right to privacy as a way to kind of bump it up. Blackmun says that privacy could be potentially found in several amendments, but his preference was the 14th Amendment, which reads, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. nor shall any state deprive any person of life, liberty, or property without due process of law. And for Blackmun, privacy here is implied as a subset of liberty in the 14th Amendment. So again, to summarize here, Roe v. Wade makes the following case. There is an unstated but demonstrable right to privacy. Abortion falls under this right, and it is deeply rooted in American history. Late 19th century state abortion bans are latecomers abrogating this right, which the court is intervening to protect. That's the first half of the case, judicial analysis. The second half is prescriptive, telling states what they can and cannot do based on this ruling, which is where things get really interesting for me. Because regardless of what you think of Blackmun's constitutional analysis, his prescriptions, that is to say the resulting law, is deeply moderate, which surprised me. In fact, I think if you were to talk to Harry Blackmun as he drafted Roe v. Wade, he would not have seen it as a radical progressive coup. He would have seen it as a kind of pragmatic compromise on a hot-button issue. I'll paraphrase his sentiments. I'm paraphrasing here. The appellant, Roe, wants an absolute right to abortions without interference from the state at any point. Texas wants to outlaw abortions from the moment of conception, save extreme dangers to the mother's health. We, the court, think they're both wrong. Texas, Supreme Court here, there's no scientific or ethical consensus on when a fetus is a morally significant human. So prohibiting abortion from the moment of conception is too burdensome and unjustified an incursion of a woman's bodily autonomy. Conversely, Roe, at some point, a fetus is a baby for all practical purposes, and killing it constitutes murder. The court cannot determine when a fetus goes from a morally ambiguous clump of cells to a preborn human deserving of protection and individual rights. But we, the court, are pretty sure by the third trimester, it's a baby. Clearly it's a baby. So we rule that abortion is illegal from that point on. Blackmun writes, we need not resolve the difficult question of when life begins. When those trained in the respective disciplines of medicine, philosophy, and theology are unable to arrive at any consensus, the judiciary, in this point in the development of man's knowledge, is not in a position to speculate as to the answer. Prior to Roe v. Wade, Texas legally set that state's threshold point of when a fetus is a baby deserving of rights from the get-go, from the moment of conception. If you go into older English common law and early American law right after the colonies became states, they used a different compelling point, the moment of quickening, when a woman first feels the child move within her. That was the legal bright line for a number of places where abortion law kicked in. In Roe v. Wade, Blackmun selects viability as the legal bright line of unborn rights in American law. He writes, with respect to the state's important and legitimate interest in potential life, the compelling point is at viability. This is so because the fetus then presumably has the capability of meaningful life outside the mother's womb. State regulation protective of fetal life after viability thus has both logical and biological justifications. If the state is interested in protecting fetal life after viability, it may go so far as to proscribe abortion, which is to say outlaw abortion. He also maintains that the state has a vested interest in regulating abortions in regard to protecting the health of the mother by licensing competent physicians, mandating reasonable locations, prohibiting risky procedures, and so forth, with risks presumably mounting as pregnancy continues. So, Roe v. Wade establishes a trimester schedule. In the first trimester, a woman's doctor may elect to perform an abortion without interference from the state for whatever reason. This is another interesting thing I didn't know until I read the case. Roe v. Wade doesn't actually legally confer women with the right to have an abortion. That's not what it does. It authorizes doctors to perform abortions, although functionally that ends up being the same thing. In the second trimester, physicians may perform abortions, but states may impose reasonable health regulations, a la banning risky late-term procedures. And abortions are outlawed by Roe v. Wade in the third trimester unless the doctor deems it medically necessary to save the life of the mother. That prescription is subsequently modified in 1992 by Casey v. Planned Parenthood, in which, among other things, the court determined that medical advances had by then moved up the point of viability from 28 weeks, where Roe set it, to 23 or 24 weeks, where the law stands today. But Casey v. Planned Parenthood is essentially modifying and affirming the underlying decision of Roe v. Wade, so we're going to focus on that this episode. In Roe v. Wade, the court rules 7-2 in favor of Roe. Dissenting opinions come care of Justices Byron and Rehnquist, who basically respond by saying, yeah, you guys just made that up. You just invented a constitutional right to abortion where there clearly is none. Rehnquist goes further. He says, look, if abortion were already an unenumerated right, why would the states, most of which had abortion laws at the time of the 14th Amendment's ratification, have ever agreed to ratify it? The only logical conclusion is that nobody who drafted or passed the 14th Amendment thought its right to liberty included a right to privacy, which included a right to abortion. The case isn't enshrining and protecting an existent historical right, it's creating one out of judicial fiat. While Blackmun alludes to a right to privacy in several amendments, he does specifically root it in the 14th Amendment as his sort of main argument. Nor shall any state deprive any person of life, liberty, or property without due process of law. Well, according to Rehnquist, that amendment pertains to due process. It says without due process of law. It doesn't say the state shall never deprive people of liberty. It says it shall not deprive them of liberty without following proper legal procedures. Well, did states with abortion statutes not lawfully pass them through duly elected legislatures? If so, then due process has not been abrogated. And even if you can infer abortion via privacy, via liberty, and then 14th Amendment, the states did not prohibit it without due process. Thanks, Mr. Rehnquist. So here's my take. By the way, I'm not a Supreme Court justice, but here's my take on Roe v. Wade. I think Roe v. Wade is pretty good policy and bad jurisprudence. I would vote in favor of it if I were a senator, but I would rule against it if I were a judge. As a senator, the person vested with creating laws in our democracy, I would vote for a bill which protects legal abortion in the early stages of pregnancy but outlaws non-therapeutic abortion in the third trimester, for the exact reasons Blackmun states, reasons I happen to agree with. I don't think a fetus is a full human being with rights and privileges and moral considerations a week after conception. I think a day after pill or first trimester abortion does not constitute murder and therefore should be legal. It's a medical procedure. But I do think that a fetus is definitely a baby a week before birth, and aborting it for non-therapeutic extenuating circumstances would constitute murder. I don't know where that bright line is, and it makes me deeply, deeply uncomfortable because I find myself simultaneously believing in the idea that you own your own body and the state can't dictate to you what you do with it, and therefore I want to defend the bodily autonomy of women. But I also don't want to murder babies, and I don't know how you can argue that at some point a fetus is indeed a baby. And I think the right to bodily autonomy falls short of a right to committing murder. So I don't feel 100% certain on my ethics on abortion, or rather the bright line of it. I doubt I ever will. I don't know how to precisely determine that threshold point and suspect that I am doomed to live in a kind of gray area and just try my best. Although, we are going to dive into that topic. This is today's jurisprudence, right? Today's constitutional law. But we're going to dive into the nature of abortion itself and its ethical implications in this week's bonus episode. My good friend, Dr. Andrea Jones-Roy, reached out to me last week and said, not only was she very pro-choice, she didn't actually know any pro-life people, but she wanted to at least figure out where they're coming from, so she asked me if I knew anybody who could give her a thoughtful explanation of the pro-life position. And I said, in fact, I do, my very good friend Josh Jennings. So the three of us have recorded a bonus episode that is a very good conversation about abortion and what is right and what is wrong and how we have come to that conclusion, all three of us, where we stand, how we got there. We planned to talk for 45 minutes. It wound up lasting 2 hours, but I think it's a good chat the whole way. If you were baffled by the crazy perspective of the other side, whatever that is, and genuinely want to understand what the pro-life or pro-choice people opposite you are thinking, if nothing else, just so you can better argue with them, it's a very good listen. Conversely, if you just want to fight with people and pound the table, you're not going to enjoy it because it's much more of kind of a thoughtful, friendly conversation on a really heated topic that we managed to navigate without killing each other. That long-form conversation on abortion, which is astonishingly pleasant given the gravity of the topic, will be available this week as a special extended bonus episode to patrons of the show. You can join them by going to patreon.com/Andrew Eaton. And we're back. So Blackmun's prescription on first trimester abortion bans, coupled with the threshold of fetal viability, after which point most abortions are illegal, strikes me as a pretty good policy framework, something akin to what I would vote for if I were a senator. But if I were a Supreme Court justice, and it was my job not to make law, not to craft policy, but to assess laws as written, I would have sat there between Rehnquist and Byron, scratching my head, saying, Dude, what's next? Spock has a human foster sister we've never heard of? Just how hard are you going to retcon this? This is a rational, level-headed policy you've created, but it's not your job to craft legislation. It's your job to clarify the contents of the Constitution. And on that note, how on earth did you infer a trimester schedule from the Constitution? Where in the Constitution did you get 3 separate trimesters? You didn't. It's not there. You made that part up. Again, good policy, but you definitely made it up. Okay, so listen. I'm not a constitutional lawyer. My legal training mostly consists of me hanging out with judges at barbecues and a lot of interesting legal conversations I've had with attorneys after seducing them. I'm a pretty good constitutional law analyst by comedian standards, which is exactly why I am not arguing con law in front of an appellate court, but instead am actively working on an erotic judicial thriller called Stiff as a Gavel. She can't recuse herself from hot sex lust. The true story about how a nubile 25-year-old Supreme Court justice saved jurisprudence through a cloakroom tryst with a billionaire Solicitor General astronaut, and also one of them is a werewolf. So I'm not a constitutional expert. But Roe v. Wade strikes me as a fairly glaring example of judicial activism, where the court said, look, this really ought to be a law. So we're going to work really hard to figure out how to claim it already is one. If you disagree with me on that jurisprudential analysis, that Roe v. Wade is more judicial activism than affirming existing constitutional rights, I want you to try out the following thought experiment. Using the logic of Roe v. Wade, what right could you not infer as constitutional? What would not apply to this? Does the Constitution guarantee you a right to vacation, to sensual massages, to cocaine? You could pretty well use Roe v. Wade logic to invent any one of those rights. For starters, what personal decision could not be construed as a private decision? I can't think of many. By Roe logic, most anything which involves you making a decision personally would therefore be a matter of privacy and therefore constitutionally protected. And you could cherry-pick examples of whatever you like historically. Coca-Cola used to have cocaine in it. Therefore, you are protecting a historic fundamental right to cocaine. Our British friends have an unwritten constitution, and it seems to work pretty well over there for them. Shout out to the listeners in the UK. We don't have that system. We have a written constitution. If we can shoehorn in whatever we'd like, and there are a lot of things that I would like to add to the Constitution, mind you, then it doesn't actually constitute anything. It's just a big game of Mad Libs for unelected super senators. Now, very likely, several of you at this point are thinking, okay, sure, but individual rights are not subject to majority rule. They're precisely why we have a Constitution. And I agree. We don't let the public vote on what speech is acceptable or what religion we all have to follow, nor should we. So if abortion is an individual right which should not be curtailed by the majority, it shouldn't be up for debate by statutes and regulations and ordinances. But the question is not what should be in the Constitution. The question at hand is, by what mechanism do we enshrine and protect those individual rights which we put beyond reach of the majority? In our country, we do that through the Constitution via a prescripted process of debate, amendment, and ratification, which I will posit, though fraught, is a superior system to indirectly appointing 9 people who get to decide what rights should exist or not. If individual rights are created and protected by unelected judges, they could go in any direction. I don't see any reason to think that that system would always favor what you and I want. Maybe they're not going to go the direction we want. You could have judges rule that we have a constitutional right to safety from harmful and agitating ideas. I can think of a few people who would like that to be the ruling of the land, thereby chipping away at freedom of speech. Or it could go far right, that personhood is going to be defined as beginning at conception, and so all fetuses have constitutional rights. And if you're thinking, isn't that what the Republicans are primed to do with Alito's leaked decision? Aren't they just putting their guys in to make the abortion law they want? No, not really. For one thing, they're doing the opposite of something anti-democratic because they are taking a hot-button issue out of an unelected body and punting it to Congress and the legislatures. The problem people have right now is that the legal right to abortion is about to become more democratic, not less democratic. The undemocratic equivalent would be if Alito et al. Tried to use the courts to ban abortion, define personhood as happening at conception or some other word choice trick, and outlaw it federally by decree of 9 unelected wizards. They're not doing that. By overturning Roe v. Wade, they are transferring the apparatus which governs abortion law from unelected courts back to the democratic process. Although, as we'll see, Republicans will probably try to redefine personhood legislatively, but at present we're concerning ourselves with jurisprudence. And insofar as that goes, I think Roe v. Wade is pretty weak. I did a lot of reading over the last 2 weeks in preparation for this episode. I actually had to push the episode back a week because I kept finding more things to read about. And I can tell you, not a lot of pro-choice outlets are going out of their way to explain why Alito's takedown of Roe v. Wade is bad logic, or are staking their case on the merits of Roe v. Wade as a solid legal ruling. Maureen Dowd wrote a piece in the New York Times about why abortion is an important right and that states enacting abortion restrictions constitute a step backwards. I agree. But the closest she comes to defending Roe v. Wade is saying Alito, quote, wants to ban abortion largely because he says the Constitution doesn't expressly allow it. That's so fatuous. The Constitution doesn't mention an awful lot of things that the court involves itself with, end quote. So, hand-waving. Basically, the outcome of Roe v. Wade is correct and important, therefore the reasoning it uses is immaterial. I think she dedicated really 1 or 2 lines to actually analyzing the case, if that. Well, that's not how courts work. That Congress can act that way. That's not how jurisprudence works. She goes on to make a lot of character attacks against Alito, then Clarence Thomas, Trump, and Newt Gingrich, but nothing about why Roe v. Wade is good judicial analysis or spelling out how abortion is in fact constitutional and Alito is wrong. Quite a few publications are sidestepping that question entirely. They're not even making the case that Roe v. Wade is a solid constitutional argument. They're just moving on to try to delegitimize Alito's ruling through character attacks. The worst story I've seen in this regard comes from ProPublica. Their headline reads, Draft overturning Roe v. Wade quotes infamous witch trial judge with long discredited ideas on rape. The Washington Post ran a similar piece. On Roe, Alito cites a judge who treated women as witches and property. Vanity Fair got in on it with Samuel Alito's anti-abortion inspiration, a 17th century jurist who supported marital rape and had women executed. And Boing Boing opines, meet Sir Matthew Hale, the 17th century misogynist that Justice Alito mentioned 9 times in his leaked SCOTUS opinion. Now, I do this for a living, and I take a lot of pride in knowing what I'm talking about, instead of shooting from the hip as a vacuous gas bag. So I took the wildly eccentric step of actually reading both Roe v. Wade and the leaked Alito draft before forming an opinion of them. Frankly, I am not convinced whoever wrote that Boing Boing piece bothered to do that. So who's this Sir Matthew Hale guy? The headlines make it sound like Alito read a book by an old bigoted rape apologist and thought, well, this guy's brilliant. I'll outlaw abortion. Therefore, because Alito's intellectual godfather is this horrible monster, his opinion must clearly also be bigoted claptrap that you can dismiss. So, not sure if you've encountered these headlines, but Alito is not championing Sir Matthew Hale, who I'd never heard of prior to this, as some kind of moral or philosophical luminary. Rather, he cites him as an authoritative jurist of English common law. Because, as you'll recall, Blackmun was relying on substantive due process in Roe v. Wade. So he had to make the case that abortion is a historic right in America and in her jurisprudential antecedents. Thus, in rebutting Roe v. Wade, Alito offers his own counter-historical analysis of abortion law by describing laws in America and in its judicial antecedents wherein the government concerned itself with the regulation of abortion and treated certain instances of it as criminal. Thus, Alito quotes several examples of English laws against abortion, including quotes by the English jurist Matthew Hale, as evidence that English common law proscribed abortion after quickening. he's not citing Hale as an intellectual forebear or a philosophical exemplar. He's citing him as a judge who authoritatively knew English common law. It would be kind of like if you were quoting in the future elements about the American military, and to prove it, you were quoting passages from General Patton's diary. I don't know a lot about General Patton. Theoretically, if he were a rapist or something, it wouldn't really be related to whether or not he was describing the state of the American military. So it's that kind of thing. And the fact that a bunch of media outlets are trying to discredit Alito's opinion by linking him to a 17th century, apparently rape-happy, witch-hunting misogynist, as opposed to the, I'm sure, many woke jurists back in old-timey 17th century England, instead of actually bothering to argue against the essence of Alito's opinion, that tells me that Roe v. Wade is too weak to stand on its own judicial merits. So its proponents aren't bothering to try to defend it. They're going for the player rather than the ball, which is a bad sign for the pro-choice crowd, at least so far as courts go. If most of the arguments against Alito's leaked draft are arguments against him rather than his ideas. Now, that's my take on it, but charitably, it might be that those headlines I just read are just a lot of hacks in journalism who can't be bothered to read the crap they're bellowing about. And one of those hacks seized on Matthew Hale, wrote some logical fallacy clickbait about it, and then the other hacks saw that on Twitter, took the premise, and squeezed out their own imitations. So, possible that that's what's going on. I will note, to be very fair, this is an anecdotal media observation on my part. There certainly are publications giving a platform to law school professors who are arguing in favor of Roe v. Wade. They are out there. There are people that support it. There are people that believe it is good law. I just don't see those headlines very much, and when I do, I am unconvinced by their arguments. But I don't wish to indicate that there's a consensus that it's bad law. It is certainly contested. The best case I've seen in favor of Roe v. Wade, against Alito's position, also comes from the New York Times by Bret Stephens, who basically says, yeah, okay, Roe v. Wade was loose, poor jurisprudence, not very good. But America has had 50 years to come to terms with it. Overturning Roe v. Wade is going to throw diesel on that topic, spray napalm on the culture war, and open the floodgates of hell. Roe v. Wade's not good reasoning, but we should have just left well enough alone. I'm sympathetic to this view. While I have a dim opinion of the legal reasoning of Roe v. Wade, I wasn't exactly itching to overturn it, or the ensuing national policy, which I happen to agree with. Hell, I didn't even want to do an episode on abortion at all. I'd avoided it for 3 years. So if I were a Supreme Court justice, you could maybe make the case to me about whether or not we should have heard Dobbs v. Jackson or just left things as they were. But if I were already on the court and it were before us and it was up to us to affirm it or overturn it, I would still rule against Roe v. Wade. In his piece, Mr. Stephens takes a dim view of the Supreme Court upending precedent, and many more people are aghast that the Supreme Court would apparently go back on its word and overturn its own rulings, and feel that the Supreme Court overturning precedent is akin to the Supreme Court atrophying the magisterium of the judiciary and undermining rule of law. I get wanting to maintain precedent if you like the precedent, but the idea that precedent should be inviolable once established is just nuts. Brown v. Board of Education, which prohibits racial segregation in schools, was itself overturning the separate but equal ruling established by Plessy v. Ferguson, which was a horrible decision that needed to be overturned. Just like the Dred Scott decision was also an odious decision that needed to be overturned. The court is going to make mistakes. It's going to make bad rulings, and when it does, it needs to course correct and change those bad rulings and move forward. It requires latitude to address bad reasoning and course correct. So I'm sympathetic to the idea that, man, Supreme Court, do you really want to rip the Band-Aid on this one? But underneath that Band-Aid, the underlying rule, I think, is pretty weak. Ruth Bader Ginsburg, very pro-choice, but she had her own concerns about Roe v. Wade. To be fair, I don't think she would have voted in favor of scrapping it. Otherwise, they would have done it 10 years ago. But she was not, seems to share a lot of the concerns other people had about the case itself. She thought a better approach to protecting abortion would have been through the Equal Protection Clause, focusing on gender equality rather than right to privacy. Privacy, she worried, might be too tenuous a position to defend, weakening the Roe v. Wade decision and opening it up to attacks. On which point, I think she's been proven right. She also thought that Roe v. Wade was not a particularly good case itself, as in Jane Roe was not a particularly good case to root abortion rights in. Prior to being a Supreme Court justice, she had been an ACLU attorney, and she had represented an Air Force nurse who got pregnant. At that time, official Air Force policy was that personnel who become pregnant could either accept a discharge and leave the service or get an abortion and remain. Captain Susan Struck, whom Ginsburg was representing, didn't like either of those options. She wanted to continue serving in the Air Force, and she wanted to have the baby. And incidentally, she wanted to give it up for adoption. She didn't want the baby, but she was a Roman Catholic, and she didn't want to terminate it due to her beliefs. So Ruth Bader Ginsburg represented her and made the argument that the Air Force policy violated equal protection, freedom of religion, and right to privacy. Her main argument was, when a male in the military becomes a parent, he's not required to leave the service. Neither is he compelled to leave due to a temporary injury, like a broken leg. A temporary medical condition which precludes his active service does not require him to leave the Air Force. So the Air Force was essentially creating unequal rules based on gender. Notice two things about that case as well. The thrust of it rests on a woman's choice rather than the legality of abortion. It was rooted in choice, and the roles were inverted from that of Roe v. Wade. The plaintiff that RBG was defending wanted to keep the baby, and the state wanted to compel abortion. So she thought that that would have been a better instigating case for abortion law. But she also worried about its scope. Rather than the court striking down a specific Texas law as too restrictive, Roe v. Wade went further. It instructed the abortion laws of the entire country and dictated what the trimester schedule would be in a sweeping judicial decision, instead of small strategic incremental ones. Here's Ruth.
I had written a comment on Roe v. Wade, and it was not 100% applauding that decision. What I said was, the court had an easy target because the Texas law was the most extreme in the nation. Abortion could be had only if necessary to save the woman's life. Doesn't matter that her health would be ruined, that she was the victim of rape or incest. I thought Roe v. Wade was an easy case, and the Supreme Court could have held that most extreme law unconstitutional and put down its pen. Instead, the court wrote an opinion that made every abortion restriction in the country illegal in one fell swoop. And that was not the way that the court ordinarily operates. You know, it waits till the next case and the next case. Anyway, it was that some women felt that I should have been 100% in favor of Roe v. Wade, and because I wasn't.
I think RBG is right about Roe v. Wade being too much too fast, prompted a backlash, one that we're still living in. In Roe v. Wade, Blackman points out that even then, states were already in a process of liberalizing their abortion laws. In 1973, when the ruling came out, 16 states, including that of Governor Ronald Reagan's California, had just liberalized theirs. Well, Roe put a stop to that grassroots, bottom-up democratic process. Whatever momentum had previously gone into liberalizing abortion laws through state elections got instead funneled into national organizations either defending or agitating against Roe v. Wade. Before the decision, pro-life and pro-choice views were widely distributed across both parties, and I realize that's a weird thing to say, that if we were to go back to like 1960, there wasn't a pro-life or pro-choice party. In fact, if you went back to 1960, I think you could make a decent case that it might have been the Democrats that wound up being the pro-life party. The Democrats were, after all, the party of Southern Baptists and Northeast Catholics, and that the pro-life party might wind up being the Republicans, which was the party of coastal establishment types like Nelson Rockefeller and Western libertarians like Barry Goldwater, or for that matter, liberal Republicans like Justice Harry Blackmun. Remember, the guy who wrote Roe v. Wade was a Republican, and he was appointed by a Republican president. So it wouldn't have been a huge stretch to think that the Republicans might have gone the pro-choice route at that time. But after Roe v. Wade, the Republican Party responded to the decision by adopting an ardently pro-life position in terms of electoral politics, which has since become virtually required for anyone in the GOP running for any office of note, a phenomenon which hastened the rise of the religious right and gave it its own coalition to dominate. Whereas previously this admittedly fraught topic was slugged out democratically in state legislatures through which voters could voice their opinions, the Supreme Court declared, nope, this is over and it's not open to debate from normal democratic channels, which has been a source of energy and frustration and propulsion for angered right-wing populists ever since, who feel like they have been shut out of an important national conversation about their deepest beliefs involving life and murder, and have rallied against the establishment since then. Had we left the debate over abortion to state law or constitutional referendum instead of judicial fiat, I think we would have cohered around a reasonable resting place by now, a position that is broadly agreeable to a plurality of voters. And I say that because that's exactly what's happened in virtually every country in Europe, which, to my knowledge, have not arrived at their abortion regimes through judicial fiat, but did it legislatively. In the course of this week's episode, I was surprised to learn that most of our European counterparts actually have more restrictive abortion laws than the United States does. Or to be careful with my wording here, most European countries have better access to early abortions than Americans do. They don't have to go to separate facilities. It's just provided in a hospital. There are more of them. There are more doctors doing it. And a lot of the time, the countries they're a part of, the government subsidizes it. So they've got better access. But their timeline is demonstrably more restrictive than that of the United States. There are more abortion providers, but the cutoff date for when you can have a voluntary non-therapeutic abortion is more restrictive than that of the United States. Here in America, under Roe v. Wade and then Casey v. Planned Parenthood, states cannot outlaw abortion before 23 weeks. The law enacted in the state of Mississippi, that law which has instigated the downfall of Roe v. Wade, cuts that down to 15 weeks, unless the life of the mother is imperiled or the fetus is severely deformed. So 23 weeks is on the books. Mississippi says, no, we want 15 weeks. In Germany, Denmark, and Belgium, abortion on demand is available up until 12 weeks. France just went up to 14 weeks, and Portugal is at 10. The outliers are Poland on one end, where abortion is illegal, and the United Kingdom and the Netherlands on the other, where non-therapeutic abortions are available up to 24 weeks like us. But for the most part, the Mississippi law, which is leading to the overturn of Roe v. Wade, is less restrictive than that of continental Europe. Now, I'm not saying that absent Roe, abortion would not have been a polarizing issue and napalm in the culture war. I'm also not saying that once Roe versus Wade is overturned, Republicans will be content to restrict abortion to merely 15 weeks. However, I do suspect that our European neighbors arrived at their abortion regimes with stable laws of consensus and windows which are admittedly shorter than that of the preference for progressive activists over here would like, precisely because they were able to hammer it out democratically until arriving at homeostasis. We've never had homeostasis. We just had top-down judicial fiat, which was well beyond that of most European countries, followed by decades of people voting for a president to indirectly appoint justices they hoped they would agree with and might eventually overturn the law. And that eventually happened. With the demise of Ruth Bader Ginsburg, the court seat was replaced with Justice Amy Coney Barrett, and the balance of the court tipped, which brings us now to Alito's leaked draft of Dobbs v. Jackson Women's Health Organization and the prospective end of Roe v. Wade. But before we jump into that, I imagine by now I've angered a bunch of people who are either pro-life and angry that I'm pro-choice, or are pro-choice but are angrier that I'm not angry enough, or that I would not make voluntary abortions available in the third trimester, so I'm really a sneaky pro-lifer or something like that. So before we continue, I just want to remind you, I'm a good guy. This is a fraught topic. Please don't hate me. I'm doing a lot of research. I'm trying my best. And once again, to drive that point home, I have booked a special musical guest to tell you why you shouldn't be mad at me. Mike, go ahead. Play it, Mike.
Please don't cancel me for knowing Heaton. No, I barely know him just enough to greet him. Oh, and if I must, I would throw him 'neath the bus. Yes, it just ain't worth the fuss. He's such a firebrand. Don't you cancel me. Cancel Heaton. Cancel Heaton. Oh, don't you cancel me. Mike TV. Cancel Heaton. Cancel Heaton. Cancel Heaton.
Thank you, Mike TV, for that wonderful song. Tell you what, let's jump from Roe versus Wade to the court case poised to upend it. Dobbs v. Jackson. In 2018, the state of Mississippi passed the Gestational Age Act, the one that I was just talking about, which bans abortion after 15 weeks, 7 weeks shorter than the 23-week limit mandated by KCV Planned Parenthood. One day after Mississippi passed that law, the singular abortion clinic in that state sued for an injunction. The district judge said KCV Planned Parenthood establishes the threshold of abortion prohibition at the point of viability, understood to be 23 or 24 weeks. 15 weeks is clearly less than this, and well before the point of medical viability. Thomas Dobbs, who the case is named after, arguing for the state of Mississippi, said, "Abortion at 15 weeks and beyond involves crushing and tearing a fetus apart, which is barbaric as well as dangerous to the mother." Further, he argued, that while viability is, yes, at 23 weeks at present, the point of fetal pain is at 15 weeks. Therefore, a better bright line would be fetal pain rather than viability, and we urge the court to adopt that. The judge said, fetal pain is irrelevant to existing constitutional precedent regarding abortion, which only concerns itself with viability. Your state law is hereby struck down. So Mississippi appealed to the Supreme Court, which will presumably rule on the case in June. And the draft of the majority opinion regarding it, written by Justice Samuel Alito, has been leaked, and here we are. Here's a passage from Alito's draft, which I think is pretty emblematic of the tone and substance of it. Quote, "Roe was egregiously wrong from the start. Its reasoning was exceptionally weak, and the decision has had damaging consequences. And far from bringing about a national settlement of the abortion issue, Roe and Casey have inflamed debate and deepened division," end quote. Then later, I think this is kind of the thesis statement to the whole thing, Roe was remarkably loose in its treatment of the constitutional text. It held that the abortion right, which is not mentioned in the Constitution, is part of a right to privacy, which is also not mentioned. Roe expressed the feeling that the 14th Amendment was the provision that did the work, but its message seemed to be that the abortion right could be found somewhere in the Constitution and that specifying its exact location was not of paramount importance. I'm not going to dissect Dobbs v. Jackson nearly so much as I did Roe, because I agree with that central thrust, that Roe v. Wade created a new constitutional right through judicial fiat. And we've already covered that reasoning, so I'm not going to relitigate that here. However, I will mention a couple of things that stand out to me about the opinion. At one point, Alito writes, "Nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion. Presumably, this is to quell concerns that the court is preparing to undo other court cases which struck down conservative laws about race or sex." Well, potentially. I've not had time to read through Hodges v. Overfell, although I probably will. Hodges v. Overfell is the Supreme Court case, which mandated single-sex marriages throughout the country. It struck down any state bans on single-sex marriage. But based on its summary, I think a lot of the court's reasoning in Dobbs v. Jackson, that this was an issue historically given to the states and has been co-opted by SCOTUS without a sound constitutional bearing, yeah, I think that might apply. For the record, I am also very, very pro-gay marriage. In fact, I am more in favor of gay marriage than abortion because I have zero misgivings about it, and I'm not worried about a bright line or gray areas or balancing slavery against murder. I'm just flat out 100% for it. I don't think the government should be involved in the marriage business at all, just enforcing contracts. But if we're going to have this weird system where the state enforces contracts but also sort of sanctifies and acknowledges sacraments, then yes, in that weird case, I am adamantly in favor of gay people having the exact same rights as straight people. And for that matter, polygamy. As far as I'm concerned, consenting adults are consenting adults, and I don't care how many of them there are and if they're wearing bonnets or not. Although I will admit I am very much an outlier in that regard. For whatever reason, polygamy still remains very much illegal and unpopular. So if Hodges v. Overfell was revisited by the court, I see no reason that current members would affirm that decision. I haven't had time to read it, as I said, but if it is relying on substantive due process and thinly veiled judicial activism, then yeah, it would appear to be on shaky legal ground. That said, I don't think the court will deign to hear challenges against it. I think it's probably safe. Abortion is a way more hot-button issue. There are two mutually exclusive and horrible options when we're discussing the legality of abortion. Either A, the state is enslaving women, or B, it is allowing for the murdering of children. Now, you can be personally opposed to gay marriage, but tolerate it as a practice in others. But it's a lot harder to tolerate slavery and murder. So I think that Hodges v. Overfell is not going to invoke the same amount of ire in people. They can kind of live and let live with that. Second, nobody's really itching to overturn gay marriage. When Donald Trump accepted the Republican nominee back in 2016, he just kind of flatly denied the possibility of trying to overturn Hodges v. Overfell. He kept saying, look, gay marriage is settled law, and he kept moving forward. All the Republicans who were worked up about gay marriage in the 90s have realized their nephew's gay, or they are. When the court ruled on Hodges v. Overfell, it was basically affirming the cultural consensus of the country. In 1997, only 27% of the public favored gay marriage, just a quarter of the population. As of 2021, fully 70% of the American public is in favor of gay marriage, and that includes a majority among Republicans, in addition to a massive majority among Democrats and independents. So I can see how Dobbs v. Jackson would theoretically imperil gay marriage, assuming that it is relying upon the same type of reasoning as Roe v. Wade, but I don't think it's a practical likelihood. If you were a woman, you definitely should be worried about legal access to abortions. That is a thing you should be worried about. When Roe v. Wade is overturned, states are going to start clamping down on that. That is a thing. If you're gay, I don't really think you need to be worried about the status of your marriage. I don't think anybody's agitating to overturn that. Now, do I need to bring up interracial marriage? Because I keep seeing on Twitter and in headlines that the next step Republicans will take in their march to the Handmaid's Tale is to ban interracial marriage. No. First, I don't think anybody on the Supreme Court has the slightest desire to ban interracial marriage. As evidence, I know of at least one of the Republicans on the Supreme Court, Justice Clarence Thomas, who's a black guy married to a white lady. So unless he's really conflict-averse and hoping to indirectly finagle an annulment, I doubt he'd be in favor of an interracial marriage ban. The Supreme Court doesn't want that, nor does anyone else in the entire United States. A whopping 94% of the American public favors interracial marriage, which, bright spot here, yay America, that number stood at a dismal 4% as of 1958. 4% of the people in the country wanted to legalize interracial marriage. Now, 94% does. The vast majority of people in America go, yeah, you can marry whoever you want according to race. Good job, us. But even if it were a contentious topic, which it's not, I still don't see how the reasoning of Dobbs v. Jackson overturning Roe v. Wade would even potentially apply to it. The Supreme Court case which bans state prohibitions on interracial marriage is Loving v. Virginia. The state of Virginia had an interracial marriage ban, and it argued that that ban did not violate the Equal Protection Clause because the bigoted law was equally punitive to all races involved. White and black people were both equally prohibited by law from marrying each other, so Virginia said, see, we're treating white and black people the same under our bigoted law. Therefore, it's constitutional. And the Supreme Court said, no, your law is clearly designed to deprive people of equal rights based on race. Struck down. That is to say, the reasoning underlying Loving v. Virginia and the constitutional rights it invokes are entirely different than that of Roe v. Wade. So anyone saying this decision imperils Loving v. Virginia is peddling you some fear-mongering claptrap. They're trying to delegitimize Alito by groundless fear and partisan character attacks, or they're trying to get you really animated to go out and vote Democrat in the midterms. But if you find anybody bringing up interracial marriage as a potential fatality of overturning Roe v. Wade, I would advise you to find a smarter, higher quality critic of Alito and his ruling, rather than somebody peddling clickbait or very much a partisan agenda. Now, you can contrast the country's evolution on gay marriage and interracial marriage, which is both welcome and demonstrable, with the nation's position on abortion, which is basically where we were 50 years ago. In 1976, 54% of the public thought abortion should only be legal under some circumstances, 21% thought it should be illegal under all circumstances, and 22% thought it should be legal under all circumstances. In 2021, 48% of the public thought abortion should be illegal under some circumstances, 32% thought it should be legal under all circumstances, and 19% thought it should be illegal under all circumstances. So I know I'm throwing a lot of math at you there. There's a 2% difference, which is within the margin of error, I assume, on people that think it should never be legal. And there's been, I don't know, what is that, a 6% shift of people that go, it should be legal sometimes, to people that think it should always be legal. But basically, it's not significantly different than where we were when Roe v. Wade passed. The country has not evolved or changed in its thinking on this. It's about where it was. And in case you're curious, because I looked into this too, there's really not a gender division on the issue. I had sort of anticipated it being women being sort of enthusiastically pro-choice and men being very pro-life, but that's not the data. The idea that men can't have babies, so we're trigger happy with abortion laws, but women understand pregnancy, so they're pro-choice is perhaps logically true, but it's not emblematic of the data. The genders are equally divided on this one, with women being marginally more pro-choice than men. In the most recent Gallup poll, the exact same amount of men and women thought it should be illegal under all circumstances. They're lockstep. More women did think it should be legal under all circumstances than men, but by 6%. Or to put this another way, I think you would be fair in saying that women are about 6% more pro-choice than their male counterparts, but that's not a significant yet. All right, back to Alito and his decision. The next thing that stood out to me in Dobbs v. Jackson was the following phrase. The regulation of a medical procedure that only one sex can undergo does not trigger heightened constitutional scrutiny unless the regulation is a mere pretext designed to effect an invidious discrimination against members of one sex or the other. So here, Alito is basically trying to preempt an argument against him that the ruling would violate the Equal Protection Clause of the Constitution, or rather that state abortion laws would violate the Equal Protection Law of the Constitution. And what he's saying is abortion laws on the state level or congressional level don't violate equal protection because they're not targeting a gender, they're targeting pregnancy. It just so happens that one gender gets pregnant and the other one doesn't, but that's correlation rather than causation. That feels kind of fishy to me. Maybe that's brilliant and I'm missing something, but it sure sounds like a tautology. I thought that part of his argument was rather weak. I have some other nitpicking notes, things that I disagree with Alito on, but on his central criticism, I think he's right. I think it was an example of judicial activism, and it's pretty difficult to arrive at the ruling of Roe v. Wade if you were trying to realistically and earnestly read the Constitution in terms of what is actually in there. But here's something I did notice in Dobbs v. Jackson which I think is worth pointing out. Let me read a line to you. Roe and Casey must be overruled, and the authority to regulate abortion must be returned to the people and their elected representatives. By my count, Alito says some variation of that line 7 times throughout his decision. Return authority to the people and their elected representatives. Or rather, I want you to take notice of what Alito isn't saying. At no point in his ruling does Alito say, this is a states' rights issue, or the court finds that the regulation of abortion is constitutionally left to the states to determine, or some variation thereof, which is what conservatives had been saying for the last half-century. The late Justice Scalia shared Alito's point of view that abortion should not be judicially imposed by unelected jurists, but arrived at through argumentation and democracy. But as I recall, Scalia viewed it as an enumerated right that would default to the states, since it wasn't granted to the federal government. Alito never says that. He says the people and their elected representatives, no reference to states, states' rights, or legislatures. And that is because, I think, Alito is anticipating a nationwide congressional ban on abortion coming about when Republicans eventually take Congress and the White House. And he has authored his position to enable legislation that would ban abortion nationally, rather than being countermanded on a states' rights ground from his decision. Which brings us to what's going to happen next. If you've come this far in the episode, you probably already know, or have surmised, that overturning Roe v. Wade doesn't automatically criminalize abortion. It just permits states to do so on their own, many of which will and already have trigger provisions that will kick in the moment it's overturned. So come June, when the case is presumably overruled, abortion will not suddenly be illegal in the United States, although it will in various states, and it'll vary in state to state in terms of when it is illegal. Many conservatives are trying to assuage fears and say that panic over the demise of Roe v. Wade is overblown, and they point out that most abortions already take place in blue states that will be unaffected, and that the various trigger provisions red states have in the books, which will kick in following the repeal, will only reduce abortions by about 10%. And even most red states still permit abortions at the beginning, which is when most abortions occur. Okay, that's all true now, at this moment, but I don't think that will be true after Roe v. Wade is overturned. It's very naive to think that once Roe v. Wade is off the books, the issue of abortion will simply default to individual states, and everyone will cheer the laboratory of democracy and say Texas can do its own thing while California does something else. We all move on to focus on something else. That's not how this is going to go down. The United States, for good reason, decided that slavery couldn't be an agree-to-disagree issue on a state-by-state basis. Slavery constituted too great a moral evil to be permitted to exist piecemeal, just to avoid conflict. And that's very much how both pro-life and pro-choice activists feel about this issue. Pro-life politicians are not going to be okay with outlawing what they literally believe to be murder in the state of Texas, but keeping murder legal in California. Pro-choice politicians in blue states are not going to be all right with what they see as red states violating a core individual right which ought to be constitutional, and the lack thereof results in a kind of female slavery. They're not going to be okay with that. The next phase of abortion law in the country is twofold. First, get ready for states trying to interfere with each other on a state-by-state basis. Blue states are going to start erecting abortion clinics on their borders with red states in hopes of making it easier for women to access abortions who might otherwise be unable to due to a lack of time or money. And I would imagine you're also going to see a lot of nonprofits spring up to give financial assistance to such women in red states. And subsequently, I predict you're going to see red states try to ban such charities from operating in their domain. I can imagine Texas or Alabama attempting to outlaw charter buses to out-of-state abortion clinics or interfering with funding mechanisms. I also suspect that red states will keep restricting the timeline for legal abortions to earlier and earlier dates. Part of that might be cynical. It might be that Mississippi would not have been able to do 6 weeks, but they thought they could pull off 15 weeks. But even if that's where everybody is right now, I think the way our current electoral system is set up is you're going to get ahead in Republican politics by being the most pro-life guy in the primaries, which means that incoming politicians will run on it and make it law. Even if the state itself is a little bit more purple or nuanced, the guys that are going to be taking, guys and gals who are going to be taking the Republican positions, I think, are probably going to be a lot more pro-life moving forward. And that means that those red states are going to move in a more pro-life direction. Second, we're going to see Republicans and Democrats both attempt to legislate their preferred agenda at the national level via Congress. We've already seen some foreshadowing of this in the decision itself. Alito's draft is telegraphing that abortion is not going from the judiciary to the states, it's going from the judiciary to Congress. And the ideal solution, in my mind, is that we, A, have a constitutional amendment that clarifies this, although that's not going to happen anytime soon. B, that we get to the point the Europeans are at, where we argue back and forth, we hammer this out, and eventually our country democratically arrives at something a plurality of voters consider livable and workable, as opposed to having a football go back and forth every 2 to 6 years, which is what we're probably looking at in the near future. I doubt the issue of abortion is ever going to go away, but I suspect we could actually get to that plurality position. For example, despite heated Republican rhetoric about Democrats wanting to legalize partial birth abortions, most Democrats are against non-therapeutic third trimester pregnancies. Really, very few people in America think third trimester pregnancies should be legal except for saving the life of the mother or in the case of severe fetal abnormality. That's a broad opinion across parties and independents. According to the CDC, 80% of all abortions happen before 9 weeks of gestation, and 93% happen at or before 13 weeks. That is to say, most abortions take place during the least controversial period of gestation, and relatively few take place during the period where people start to worry about literally murdering a baby like me. Theoretically, if you made Mississippi law the national template, it would ban up to about 7% of legal abortions that are currently happening. And that's assuming that all of those abortions are voluntary, non-therapeutic abortions, which they aren't. The overwhelming amount of abortions which take place in the third trimester are due to some kind of horrible medical necessity and not a woman flippantly changing her mind about giving birth. So presumably that 7%, we're very, very, very close to it, would continue anyway due to the medical exceptions that are built into these laws. So you might think 15 weeks is too restrictive or it's too liberal. Fair enough. But regardless of how you feel that bright line should be, whether it should be at conception or never, right now, if you had everyone in America vote up or down on the following proposition: should America have a legal right to abortion for up to 15 weeks and outlaw late-stage abortion except in the cases of severe medical issues, that proposition would almost certainly pass. And no doubt, if passed, such a law would be challenged by politicians in referendums, but I think we'd find that's where the electoral center of weight is on the issue. But I'm not sure we're going to get there anytime soon. Our electoral system, both at the state and national levels, effects a kind of ideological gerrymandering. We talked about this last week. The closed primaries and first-past-the-poll system we have is effectively handing leadership to the activists in both parties and letting the 80% of the country that aren't Republican or Democratic activists choose between the Republican and Democratic activists. So as of now, leaders in both parties don't represent their parties. They certainly don't represent the country or their districts as a whole. They represent the vocal elements of their party. So I think it's entirely possible that while the country at large would probably vote for a legal framework kind of similar to that of Roe v. Wade or maybe Mississippi, Democrats are going to push, or I should say Democrats running for office are going to push for legalizing all abortions under all circumstances and going well to the left of European abortion law, because that's going to be the way to drum up their base in the Democratic Party and win the primary. And meanwhile, Republicans are going to go the other direction, falling all over each other to be the most aggressively pro-life. And I don't see a way around that other than actual electoral reform, namely open primaries and ranked choice voting, which is the subject of several past episodes. But that's not here yet. So in the near future, here's what's already developing. Republican Senator Rand Paul wrote S-99, the Life at Conception Act, which would define human life and therefore all legal rights at the moment of conception. At the time of this recording, it has 19 sponsors in the Senate and 149 co-sponsors in the House. That was written last year. when such laws were still just an academic and/or signaling exercise. But one would assume after the repeal of Roe v. Wade, a lot more Republicans are going to jump on board. Last week, Democrats who control both houses of Congress pushed the Women's Health Protection Act, which would enshrine Roe v. Wade legislatively, plus roll back some Republican meddling in red states, such as obligatory waiting periods, requiring videos and pamphlets about alternate options, and so forth. It died on arrival in the Senate 49-51. Meanwhile, Republican and pro-choice Senators Lisa Murkowski and Susan Collins have written their own similar bill, which would enshrine Roe v. Wade legislatively. However, they refused to support the Democratic bill, along with Democrat Joe Manchin, because it doesn't include a provision for conscientious protection. That is to say, it does not allow doctors to opt out of performing abortions if they're Catholic or Baptist or have some other moral qualm. Both bills probably would have failed anyway, because you need to have that 60-vote threshold to avoid a filibuster. But for sure, the only way they might have conceivably passed was if Chuck Schumer and the Democrats got these two pro-choice Republicans on board with their bill, which they could have done by either just adopting the Republican pro-choice bill and having all the Democrats supported that, or modifying their bill to support the two Republican ladies. But the point of the bill that just failed was never to actually protect legal access to abortion. It was a showpiece for Democrats to sign onto and pummel Republicans with in the midterms. And so I think we're apt to see a lot of the following in Congress. Bills which neither party has any real intention of passing, but are loud and flashy gimmicks designed to motivate donors and voters. So, short-term prediction, red states are going to drastically reduce access to legal abortions and push up the dates on when you can get them, and Congress is going to float mostly ornamental, emotionally evocative gimmick bills that don't do anything. What would be great, unlikely but great, would be for either party to step up and use this as an opportunity to amend the Constitution. Here's what Republicans could do to make me and my gay friends feel a lot better. Author a constitutional amendment which says something to the effect of, no state may deny marriage permits to two consenting adults. When it comes to judicial issues, Democrats routinely accuse Republicans of being dogmatic and suffering from filial piety to the Founding Fathers and suffering from an inability to acknowledge that society and situations evolve over time, or that they're straight-up homophobes. And what Republicans usually respond with is, we're not saying there can't be change or evolution. We are saying that it should happen through amendments to the Constitution rather than through unelected judges. Also, we're not homophobes. We all love Modern Family. Terrific. Great, guys. That's awesome. Now would be a great time for Republicans to put their money where their mouth is. And all the Republicans should get together and write an amendment the majority of the country agrees with, that gay people and interracial couples can get married. Do that, and it shows you mean what you say, that you are not backwards-looking bigots, and that you are, in fact, able to modify the Constitution through democratic means. Were you to do that, the Democrats are going to have to sign on board because they also agree with that. Wouldn't that be cool? No one would disagree with this. It's unlikely, but perhaps more likely than a constitutional amendment protecting abortion at this time. I think Democrats would be smart to try to provide basic legal access to abortion at the congressional level, something that most of the country would agree with, rather than what they just did, which was resort to signal flare legislation which won't actually pass. Maybe that'll change when Democrats inevitably get rid of the filibuster. That might happen. Maybe they'll make some kind of basic abortion protection provisions. But at the moment, it seems to be a lot of signaling from both parties. And I have very little faith that either party will actually do anything in Congress, because I think the top priorities of the Democratic and Republican parties are to beat the Democratic and Republican parties. And I think abortion and everything else is just ammunition in that fight. And you and I are collateral damage. Ugh, it's kind of a downer to end the episode on, isn't it? Sorry about that. This was kind of a hearty oatmeal bowl of an episode. It was sort of a, hey, this episode's real high in fiber and a lot of gray. Just a lot of gray. But I do hope that even if it pissed you off at various points, or you took have a different position, very different than that which I have espoused, that the episode did at least provide you with a framework you can use to interpret the news going forward when people talk about Roe v. Wade and Dobbs v. Jackson, that when you hear these things, you will know what they're talking about, and hopefully you'll be able to call out nonsense from more partisan sources. That's the show. Thanks for listening. A big thank you to today's awesome musical guest, Mike TV of Get Set Go, who is kind enough to make and produce unique music for this show and this specific episode. Thank you, Mike. Check him out on Twitch at Mike TV Live. Thank you, Eric Stipe, who edited today's episode. Remember, if you cancel me, you cancel Eric. Do you want that on your conscience? No. Special thanks to attorney Tim Sandifer and an anonymous, handsome 10th Circuit Federal District Judge for letting me call them to ask questions about substantive due process, and in fact telling me to say substantive rather than substantive, as I would have otherwise done, and appeared slightly more foolish than I already have. Thank you, Hormos Rashidi, for letting me play your funny joke at the beginning of the program. And thank you, patrons of the show who make this whole thing possible. If you got angry about the Sir Matthew Hale shenanigans I mentioned above, you can thank patrons for funding someone like me to actually sit down and read stuff and do policy and judicial analysis amidst a world of shoddy, partisan, clickhole propaganda. I am able to do this because you guys fund me to do this. So thank you very much, gang. And if you were glad I was doing this, go to patreon.com/Andrew Heaton. Until next time, I've been Andrew Heaton, and so have you.